Hi, my name is Kristen Wolgamuth. I am the president and CEO here at Mountain States Legal Foundation. And this is quite honestly my favorite time of the year because it's an opportunity for us to look back on the year and especially years like this, where it has just been victory after victory to get to share with you some of the things that you made possible. So I have around me our senior legal team. Will Trackman is our general counsel. James Kerwin has joined us at the end of the year to lead off our First Amendment practice. Sean is taking care of our now our Second Amendment practice, but also our big case in Brigida, our equal protection case. And then Ivan has been with the foundation for some time and is now working for the foundation instead of assisting the foundation and is leading up our natural resources practice. And so I'm really, gentlemen, thank you for joining me for, again, my favorite part of the year, which is celebrating the victories.
Pleasure to be here, Kristen. Yes. Thanks for having us.
Absolutely. So with that, we usually have a little bit more structure to our webinars, but this is a season of celebration. So I asked the guys to be ready to just chit chat with me a bit. And so guys, Will, if you'll start us off, Tell me about what is your favorite case that you got to work on this year?
Yeah, well, you guys know that I hate race discrimination with the intensity of 1,000 suns. So, one of the major things that we've been involved in as a foundation is fighting back against racial preferences in college admissions and all around the world and in the United States, especially with Brigida, which Sean will talk about. But the fact that the Supreme Court ruled once and for all in a major 6-3 decision over the summer that affirmative action is unconstitutional and illegal, and that we played a part in that process by filing a brief with the Supreme Court on behalf of civil rights officials in the Trump administration, and that some of our arguments were echoed by Justice Amy Coney Barrett at oral argument, was honestly one of the proudest moments of my career, that we had such an impact on the landscape of American law for the foreseeable future. And that decision, because they were writing so broadly and they knew what they were doing, is going to have cascading effects for years to come. So the fact that we played a part in such a momentous decision was really a proud moment for me this year.
So, you're talking about the Students for Fair Admissions cases, one against Harvard and one against the University of North Carolina. If you don't have a kid that is applying to higher education, what does this decision mean for the average person?
Yeah, so the court's decision took place in the atmosphere of college admissions. That's how the case came to it. But its rhetoric was much broader than just about being college admissions focused. So it said that when you try to claim diversity as an all-purpose defense to race discrimination, that doesn't work. That you can't just have 5 buckets of people in the world: Asians, whites, African Americans, Hispanics, and Native Americans, and call those big groups of people that contribute to diversity, because they don't have all the same viewpoints. And the diversity that we actually have as a country is much more than skin deep. And so that's going to apply just as much at the K-12 level, in the private business setting, in any number of places where either private companies or government entities are using race as a factor. So whether that's employment decisions, who to hire, who to fire, who to promote, whether it's government decisions about who to make an air traffic controller, whether it's a K-12 school deciding we're going to have a program that only African Americans can enter, those are going to all have an impact. And it was Chief Justice Roberts who said eliminating race discrimination means eliminating all of it, that I really think is going to have an impact for many years to come.
What a tremendous victory.
I think it's absolutely right. And it's a huge moment, but I do think that there are many bureaucrats in the government who aren't going to take that message. And there is going to be a lot more work to do, just because, they will intentionally pretend it didn't happen, more or less, in these different contexts that Will is talking about. So it is a huge victory, absolutely. And it should be as plain as day to all these people that they need to change their practices, but they won't do it without further prodding from us.
I thought you were going to say, yeah, affirmative action's big, but wait till you hear about 303. That's an even bigger decision about free speech.
Well, Jim, I do think that your argument sounds very much like somebody who knows exactly what it means to get a great victory and then have mass resistance against it. So what's going on in the free speech world? What is your most favorite case that you got to work on, or that you saw happen in the courts this year?
So we have a bunch of them. We'll talk about the 303 creative case, which is a huge victory. The Supreme Court precedent came down very clearly that when the government compels somebody to say something they don't believe, that's unconstitutional, which should have been clear for a century. But the state of Colorado and many other local jurisdictions are very aggressively pushing what they call diversity and equity type programs, and into the realm of where they're not just asking people to refrain from discriminating, but they're trying to force people to state things that they don't necessarily believe. So in this particular case, this was a website designer who did not personally believe in same-sex marriages, but was required by the state of Colorado to celebrate them anyway through her work. That's a huge case. That's very important. Here at the foundation, we contributed to this case meaningfully in the amicus context, and I think it's very satisfying to see that victory.
Very nice. This feeds very well into your equal protection work also. Tell us what's going on with Brigida.
So Brigida, for those who've been following the foundation for a while, it's been going on since 2016, and it involves an Obama-era hiring decision related to air traffic controllers, where they ditched a program for kids who had gone to college specifically to become air traffic controllers, in favor of trying to rig the system to bring in more minority candidates, and did so in an improper, racially conscious way. I think we all broadly believe that diversity is a fine goal, but there's different ways of doing it, and you can't do so in a racially conscious way. So we started to get some momentum in the case. Discovery is ongoing, but we started taking depositions, and we think we've developed I think I've developed a pretty good factual record so far. Being able to demonstrate that the government was doing what it shouldn't have been doing. And we've also brought in additional counsel to add more firepower. But it's interesting in terms of sort of my favorite case at the foundation. It's one I would never have thought of in my prior career. It's actually one of Ivan's cases of ranchers versus grizzly bears. And I just love describing that case to people because it's so funny to me and so interesting as well.
Not funny to them, but I take the point.
Ivan, you have the responsibility for our bread and butter issues. Back in 1977 when we were founded, it was for natural resources issues. So what is your favorite case that you got to work on this year?
Well, I'm grateful to carry on that legacy.
Yeah.
And my favorite case for me is an easy pick. We've had a case, it's a legacy case. Back in the early 1980s, Sidney Longwell got a federal oil and gas lease that he could no longer ever use for decades and decades afterward, thanks to what the district court judge called Kafkaesque bureaucratic red tape. 10 years ago, 2013, Mountain States filed a case on his behalf. It's been a long, winding case. The wheels of justice sometimes turn slowly. But a year ago, we got the second of two amazing district court results in Sidney's favor, in Solinex's favor. The case is called Solinex. And while the federal government, who is the defendant in the case, and there were several intervening groups who are also defendants in the case, while they appealed those results over the past year, we were able to negotiate another great result for Sidney Longwell's family, for Solinex. The culmination of, like I said, literally decades of work, both on Solinex's account and on ours. We preserve in paper, in writing, in public, district court opinions that explain how the federal government wronged Sidney and Solinex, and explain that regulators who are not elected are not above the law. They don't have some ambiguous inherent authority to do whatever they want to do. Rather, they have the authority that Congress gives them, and they have all of that, but no more.
Right.
So to have that preserved in writing and then get a great settlement result which resulted, frankly, in a payment to our clients, is a great result. It's the capstone for me of our 2023.
That's fantastic. So I didn't prepare you for this question, but as I asked Will, what does Solonex mean for the broader population? Is there something that we can look to and say, you know what, this is something that is not going to happen anymore because of the work that our brave clients that will have the opportunity to honor with our Medal of Courage award this year. What does this mean for the broader population?
Well, you're right. You didn't prep me. It's a hot bench.
I didn't.
Hot bench.
I didn't.
Here's what it won't stop. It necessarily won't stop government actors overstepping their boundaries. What it does is give us further ammunition when we're fighting back. The district court's rulings were very clear, emphatic even. There are a lot of exclamation points. That regulators have the full measure of authority the legislature gives them here in Congress, but no more. Right. But no more. And actually, that's the second thing. And believe me, I've heard a lot of follow-ups on this. There are a lot of people and entities interested in what's going on, what happened with this case. When the government enters into a contract, it has to abide by contract law. Right. In this case, Solonex for a decade plus, the government didn't feel that way. Now we have black letter law saying they do.
Yeah.
That's brilliant. Yeah. That's brilliant. Well, I'm going to toss it back to you, but I'm going to ask a little bit different question. We did have the opportunity to award Sidney Longwell's widow, Seal Ann, with the Medal of Courage Award this year. Can you talk a little bit about the role our clients play and what we ask of them before we join in a partnership and pursuing the issue that they have that they bring us to work on?
Yes, so the Medal of Courage is an award that we give to brave people who put their names on federal lawsuits and become plaintiffs. But whether or not you win the Medal of Courage, if you're a plaintiff in the federal lawsuit and you raise your hand to fight for liberty, there are going to be consequences. You might have your name in the paper. You might have your friends and your family members and your social circle see that you're fighting against the federal government, generally in a way that we think of as positive, but not everyone out there thinks of as positive. Some people think that the federal government knows best, and so you shouldn't fight back against them. And those clients also have to undergo years of stress, of worry, of concern about how their case is going, whether the rights will be vindicated. You just heard Ivan talk about a 40-year process to vindicate the rights. And sadly, Sidney Longwell didn't see the end of that.
Right.
Many of our other clients are more fortunate to be able to see the end of their cases and the victories in their own lifetime. But even when you win a case, it comes at tremendous personal cost because you've had to put your name out there for years. And the government has an unlimited amount of resources, no reputational harm. The reputation can't get any lower. But you obviously have your personal blood, sweat, and tears in a case. And of course, you have me calling you every few weeks saying, here's what's going on in the case. I might need this or that from you. And so it's not like our clients, although they are getting good monetary settlements, it isn't as though our clients are becoming billionaires here. They're in it for the fight. They're in it for the principle. They're in it to make the country a better place. And so we have to find clients who are willing to put in that fight for years and years in order to see the principle vindicated.
Absolutely. And so many of our clients, they genuinely understand the burden that we are asking them to carry, and that they carry on behalf of all of us, because as these guys are sharing, the victories that we win, they definitely vindicate the rights of our client, but they also vindicate the rights of so many others, whether they are directly similarly situated or, as Will was explaining, the ripple effects of some of these cases that are going to go on for years. However, some of our clients are a little bit more excited about the opportunity to take things on.
I knew you were going. Or you must be talking about Jaden.
I am.
He's our one of our newest clients. He's this amazing 12-year-old kid. He's in middle school, but he's braver than many adults because he's standing up for his right to express himself, even though in the face of official censure. His school banned him from wearing certain patches on his backpack that expressed a couple of things: his support for Second Amendment rights, and more importantly, and in a very famous episode, he wore a patch of the Gadsden flag, the "Don't Tread on Me" flag from the American Revolution, and was told that he couldn't wear it because of it allegedly had roots in slavery. So this kid's very amazing, and he would be seeking to litigate to vindicate his rights under any circumstances. But this event became a viral sensation. It was all over the news. Even the governor of Colorado weighed in to take his side on the Gadsden flag portion of this case. And it's important for a number of reasons, to reestablish and reaffirm the rights of students in the public school setting to express themselves as long as they're not disrupting other students' ability to learn. But it's also important because this is the reasons why his speech was suppressed in particular have to do with kind of the takeover of our schools by activist educators who want to reinterpret everything from the past in the worst possible light. Who else would say that the "Don't Tread on Me" flag is a symbol of slavery and racism? Right? We're pushing back against that.
It's pretty ironic, right? That
right.
That the school is saying that "Don't Tread on Me" patch can't be allowed here. It's rooted in slavery, when of course that's what the flag is trying to fight for, freedom and against oppression.
Absolutely. All right, gentlemen, I'm going to change the question a little bit. We as lawyers have a tendency to have a little bit of a nerdy side. And we get very excited about some of the deep legal issues that we get to work on. So, and I will throw it open to whoever wants to jump in first. What is your favorite case that you've got to work on that has that deeper, more complicated legal issue? I used to joke, I still joke about one of our younger attorneys when he first got here. He was so excited because he got to file a writ of mandamus, and that was really what he was super excited about. So he went on to do wonderful things and has made that case something to shine about. But favorite?
I think I'd start with our Vanderstock case. That involves the ATF reinterpreting a statute. They issued a rule that says anything that may potentially become a firearm in the future is a firearm. So a hunk of metal, firearm. The rule before had been if it were 80% manufactured towards a fire, or more than 80% manufactured towards a firearm, then they could regulate it. Now they want to regulate everything. We and several other groups filed suit against that rule. We were successful at the district court, where there was an injunction issued. We were successful at the Fifth Circuit, which has not yet issued an injunction because of some Supreme Court procedural issues. But really, it's a kind of narrow, nerdy question of like who gets to define a rule and can an agency go beyond what Congress has given them? Because we'll see in some of the cases that are being litigated out there today, that's a very much a live issue right now.
Was Supreme Court procedural issues a euphemism for dark arts or something similar?
No. So the Fifth Circuit had issued a nationwide preliminary injunction, and the Supreme Court vacated it pending any cert appeals. There's a trend that nationwide injunctions from a particular circuit or a particular district court are disfavored. So reading the tea leaves, I think it's just that issue, but you never really know until they actually issue an opinion. But I'm pretty confident our victory will survive.
Well, it's going straight to the Supreme Court. I mean, the government's going to appeal for sure.
And that is honestly one of my favorite cases to explain, simply because, and it's not even, while I support obviously the Second Amendment principles that are tied in there, one of the foundational issues of that case really is how creative does the bureaucracy get in interpreting their own authority, right? So it has the potential to have a broader stroke than just whether or not a hunk of metal equals a fully functioning firearm.
Exactly.
I tend to say that it doesn't. But
well, and we filed a petition, or excuse me, an amicus brief on essentially the same issue involving the Chevron doctrine. And somebody bailed me out. The herring fisher. What's that?
Loper Bright.
Loper Bright. Thank you. It was in there somewhere.
Earliest case we did all year.
I don't resemble that remark, but I take it.
And I believe you took the labor.
Oh, very much so. Very much so. Very much so. Was that our intro to talk about Loper, right?
Yeah, let's hear about it.
But it is, I mean, nerdy in the mega scale. And
I like
it
that.
really is about addressing the separation of powers that is the, to me, the fundamental aspect of our Constitution that allows us to be free. And we had the opportunity to brief as a friend of the court, Supreme Court, at the merits stage, this case, that really it asks this one question: when you're going into a dispute with the federal government, and you and the federal government don't agree on how the dispute should be resolved, do you have a fair shake at the court or not? There is a long-standing doctrine which has had ups and downs. It is not a very solid doctrine at all. But some courts have used that doctrine called the Chevron deference, based on a case that involved Chevron Company decades ago, where in doubt, the courts would put their thumb on the side of the government in some dispute. We don't like that. We would rather have a neutral judiciary resolve these disputes. The exciting part also for this is that it carries over to 2024 because the case will be argued in January. And we were thrilled to have a chance to brief that at Supreme Court, look forward to the argument in the ruling. It will have really a lot of effects for a lot of our subject areas and cases, because it really kind of goes to the kernel of what can the government do, what can the different branches of government do, what are their different responsibilities, the judiciary, the executive, and the legislative branch. So that's my mega nerdy, although Sean resembles her more.
Well, I will. This is where my teacher hat comes back out, because I genuinely get excited about this because of what we've seen of this Supreme Court, which seems in every issue area to be perfectly comfortable putting everybody, and by everybody, I mean each section of government, back into its own lane. Everybody has a lane. The Constitution established those lanes, and our Supreme Court currently is just saying, okay, everybody, go back to where you belong and stay in your lane. Do what you were supposed to be doing. Don't get creative. Do what you've been told to do and stay there. So I get very excited about this, folks. But Jim, I kind of tricked you into talking about the Gadsden flag case. What is your favorite nerdy case?
Well, I'd say Loper Bright.
Yeah. Should I do a victory lap now? Or
These kind of structural issues you can get very excited about individual rights, like the First Amendment cases that I have a lot of involvement in. I love those and they're amazing, but the structural things, the way the Constitution originally sets up decision making broadly, everything is affected by the way that decisions are made, as opposed to the individual rights of somebody that can come back and limit a decision that's been made. Before you get there, you got to decide who's got the authority to make a decision, what kinds of evidence they can look at, and this sort of stuff is very important. So I found that to be a fascinating case to work on.
Excellent.
I have continued.
I have a deep cut.
Awesome.
So if you think back to law school, there's a doctrine called mootness about whether a case that used to be live can keep going or whether it's moot. And that way the government gets a chance to dismiss it. And so I've been tilting at windmills on this issue in a nerdy way this year because we have a lawsuit from 2021 involving this federal benefits program that shouldn't have ever existed, but it did exist. And some payments got out the door while we were challenging it. And so after we won an injunction halting the program, the government repealed the benefits program, which was good.
Congress, right?
Congress, yeah. The Congress appealed, and so the Congress in our suit, the government said, "Well, now it's moot. The program that you were challenging has gone away. We've got nothing left to fight about." And we've said, no. Remember those payments you made before the program got halted. The case is not moot until you've unwound those payments, figured out how to remedy the situation with our clients, because our clients are injured based on the fact that they didn't receive payments and those people did. And so we went to the 10th Circuit, and I admit that the argument was a little bit of a hot bench for sure, and they ruled against us. But just in the last 2 weeks, Jim and I have filed a petition to take it even higher to the en banc court, which would be the full 10th Circuit Court of Appeals. And if they don't say yes, then I'm going to the Supreme Court. So I'm not stopping. I will tilt at windmills all of 2024 if I have to, because this is one issue that really gets my blood boiling, that the government can say, well, water under the bridge. we've repealed the program, so the whole thing has to go away.
And I agree with you that it should make your blood boil, but I think that I want to get you to talk a little bit more about it, because I want you to explain why it makes your blood boil. What is it about this that is fundamentally, we don't begrudge the people that got the payments, right?
Yeah,
we don't
yeah.
do the loan forgiveness, but we do have a fundamental problem with how the agency went about its activities. So why is it that it makes your blood boil?
Yeah, so if you think about it, it creates a very perverse incentive for the government to commit as much unconstitutional conduct as it possibly can, as fast as it can. So it can roll out a program, try to make billions of dollars worth of payments that are illegal or unconstitutional.
Mhm.
And then when they're challenged and you join them or you beat them in litigation, they repeal it or it's struck down. And then they'll just say, look, the whole thing is moot. There's nothing left to decide, even though they just got billions out the door. And so maybe they give up on that program, but they start a new program tomorrow or a new program the next day.
Mhm.
And so you have to keep playing whack-a-mole against the government. The only way to stop that is by actually creating a pain point for them where they have to go to the people that they've already paid and say, sorry, we need that money back. Otherwise, they'll just keep doing it. There's no disincentive for them not to press the envelope every time.
Absolutely.
Push the envelope, press the button.
All of those things.
Yeah.
All right, gentlemen, last question of the day. We are mid-December and we are pushing into 2024. What are you looking forward to in our fight for liberty in 2024?
So I believe, day before yesterday, we just filed a notice of appeal in our Garcia versus Polis case involving Colorado's 3-day waiting period to acquire a firearm.
Mhm.
We think the judge, who's a Carter appointee, got it wrong, and we're asking the 10th Circuit to overturn it. And hopefully the 10th Circuit will rule at some point next year, hopefully in our favor, and then we'll brief it in front of the Supreme Court at some point in time.
So you'll have to correct me if I get this wrong, but I believe that my years are kind of blurring together, that the New York State Pistol and Rifle Association versus Bruin case was just decided at the beginning of this year. Is that right? Or was it the end of last year?
Summer of 2022.
So, okay, see, blur. Yes. But how did we get here on the Garcia case? Why does Colorado think that it has liberty to create this 3-day waiting period, given the fact that Bruin just said the Second Amendment means what the Second Amendment means?
Well, certain political groups don't necessarily agree with the Bruin decision, to say the least. There are cases, there's a pending case before the Supreme Court now where the government has explicitly asked the court to trim or actually, I believe they asked it to overturn Bruin, but at least narrow it. So it is still a live fight. Colorado and other blue and purple states primarily are going to keep testing those waters. And this is part of that sort of testing of the waters from the anti-gun groups. And we'll keep fighting them every time they do. We think we've got, if you look at Bruin's history and traditions test, we think we've got a very solid argument that there is no history or tradition in this country of waiting periods. And we think the judge just got it wrong. But that's why we fight.
Yep. All right, Ivan, what you got?
A lot of things going on. The big picture, we're filing a brief at the Supreme Court next week, but there has been an ongoing, especially during the current administration, attempt by the federal government to lock away public lands, especially in the West, away from the public. Now, it takes many different forms, regulatory forms, cases. We're fighting all of them because we continue to push back on this counter push or initial push from them to take lands in the West away from the people. So that's going to be an all year thing. I said we have a brief next week. We're staying busy. And more immediately, in January, I mentioned that Loper right would be argued at the Supreme Court. We're watching that. In another case, we filed a brief at the Supreme Court regarding what's called legislative exactions, which is where local land development boards can effectively strong arm developers to force them to pay for things that they shouldn't have to pay for. If they want this permit, it'd be a shame if your house fell down. And then actually in January, we have argument and I think one of our really important cases too, the Idaho stop water case,
Right.
where the federal government, again, this is probably to Jim's point, mega nerdy, right? Big picture, how do we go about doing our government stuff?
Yeah.
But the federal government is certainly important in the West. The federal government has sued the state of Idaho to invalidate some laws that just clarify that the federal government has to comply with state law when it's asserting rights to use water in Idaho. That's been the law in the West forever. Congress has passed a law telling its, regulators that they have to follow this law, but they don't want to. We've been briefing that for the past year, and that argument again is in January in Boise. So we have a lot coming up in the short term on our plate for 2024. That's very exciting.
Very nice. Mr. Kerwin.
So I would say almost a structural issue. One way that there's a big check on government misconduct is when people who are on the inside let other people know what's going on in the shadows. So an important free speech area involves the rights of government employees who are brave enough to speak up about things that they think are wrong, that are going on that the public doesn't know about, that they have a free speech right to do that and they shouldn't be retaliated against. And so I'm very excited that we're pushing more into this area of First Amendment law. Well, we're going to launch a case soon at the beginning of the year with just such a government employee who spoke up about what she saw going on in her employer's practices, and she had a right to do so. And we're going to be taking her fight to the courts.
Very nice. Well,
as big of a year as 2023 as I think 2024 is actually going to be even bigger. There's going to be a lot going on, as all three of these gentlemen have already mentioned. I'm looking forward to a few things. Number one, we still have University of California, Berkeley under investigation for their racially segregated graduation. Number two, we just filed a brief in a case called Coalition for TJ, which the Supreme Court may hear based on whether schools can use proxy measures as discrimination. Like they know that they want to discriminate based on race, but they'll add a layer, like we'll just target the best zip codes for our racial makeups. That is going to be a big case if the Supreme Court takes it. And then just in the last few weeks, we argued a case of the 10th Circuit called Young versus Colorado Department of Corrections. And if we prevail on appeal, and I hope that we do, we're going to have the aftermath of that case, which involves a prison guard who was forced to resign from his job based on the very aggressive diversity, equity, and inclusion training that was forced upon him and all of his colleagues in the prison setting, where he was told he's a racist, he perpetuates white supremacy, he can't help it, his merit is not his own, it's because of his skin color that he is where he is as a successful person. So I'm very much looking forward to litigating that case in 2024. And the fact of the matter is that we don't know what the future holds. I am confident that if you ask me this question a year from now, what were your favorite parts of 2024? There will be at least one thing that I have no idea is coming down the pipe right now.
Well, we really appreciate so very much all you do to help us make these opportunities, these fights happen. Mountain States was founded in 1977, and since the beginning, we have been fighting for natural resources, private property rights. We've been fighting for equal protection under the law. We've been fighting for your right to self-defense. We've been fighting for your right to speak your mind free of any retribution. And it is an honor and a privilege to get to do so. The work that the foundation does is so important, and it really has been, gentlemen, a year of victories. For those of you who are on our mailing list, I really look forward to sharing word by word, line by line, every single victory that we had this year, because they are so many. And we are, to Will's point, we are looking forward to showing you that we can do even more in 2024. So from all of us here at Mountain States Legal Foundation, we wish you and your families a very Merry Christmas, a Happy Hanukkah, and a Happy New Year. Thank you.